Okay, we've had a couple of new documents drop, so let's go ahead and look through them real quick. Hey guys, this is Jules with True Crime Reactions. As most of you know, Bryan Kohberger's arraignment was this morning, and I am deeply disturbed and aggravated and angry by the judge's unprofessionalism. Let me just say something about that little situation. This judge is from there, obviously, okay? And there is no way that A, he hasn't heard of the case before to know these names, B, talked amongst colleagues and probably friends around him about this case. I'm not giving him a pass for calling Kaylee Kayla, okay? Mispronouncing a last name and then having a comment about it the way he did Xana's is one thing. He called Kaylee Kayla twice, okay? And now it is on file in court records, in official documents, that Bryan Kohberger answered yes to the stabbing murder of someone who doesn't exist. Kayla Gonsalves? Who's that? Oh, and before we get into the documents, yes, the headset. I don't know what's going on with my camera's audio today. I go to listen to myself, and even though it sounds like it's recording correctly, the playback, you can barely hear me, like, at all. So I'm going to mess with it later, so this clunky dunky thing is just going to have to sit here for right now. Now, the first document that I see got posted today is the defense's motion requesting release of the grand jury materials under qualified protective order. And this is just basically stating that whatever was presented at the grand jury, the defense has every right to see it. And you guys remember, when a grand jury happens, the defense's side is not heard. Only the prosecution gets to go in and give this panel of people the information that they have. They don't get to hear the opposition's side. So anything that was presented to them, they have no idea if there's a retort from the defense or not. So the defense really has no clue whatsoever really what was presented there, especially since we keep seeing all of these requests to compel discovery. It seems as if the defense is pretty certain that there's stuff that they're not receiving. So I guess we're going to find out exactly what might be being hidden. Now, this next one that they filed is a motion to enlarge time to file pretrial motions and memorandum in support. And it reads like this. Procedural history. The indictment for the above entitled matter was filed on May 16th of 2023. Counsel for the defendant filed its initial request for discovery on January 10th of 2023. Counsel for the defendant filed a motion to make available the record of all proceedings of the grand jury on May 19th. That's the one that we just read. Based on the amount of time it will likely take to receive and review all grand jury materials for this matter, counsel will need additional time to file pretrial motions pursuant to Idaho Criminal Rule 12. The request. Counsel requests enlargement of time to file pretrial motions of at least 28 days from the receipt of the requested grand jury materials and other discovery materials previously requested. That almost makes it seem as if, even though the state stated in a response that they gave them everything, the defense is still stating that they didn't. As of the time of the filing of this motion to enlarge time, counsel for the defendant has not received, any of the grand jury materials. The review of such materials are critical to the adequate preparation of the defendant's defense and will cause counsel for the defendant to likely file pretrial motions regarding various evidentiary issues, challenges to the grand jury, and possible motions for suppression of evidence. See, that whole suppression of evidence thing is going back to what I just said. Regardless of the fact that the state has responded stating they've given the defense everything, the defense is adamant that this is false. So if they're correct and their suspicions are correct that their stuff being suppressed, for real, this is going to be a huge issue. Counsel makes this request for the enlargement of time based on the belief the defendant will be subject to prejudice, harmful error, and inadequate defense without the opportunity to review grand jury materials prior to the filing of pretrial motions, which is true. He definitely, the defense team definitely needs to know exactly what was given during the grand jury. That's the only way that he could be adequately prepared for these next steps. Conclusion, based on the foregoing reasons, counsel requests enlargement of time to file pretrial motions. If argument is required on the matter, the defense requests 10 minutes time. So basically this looks like it's just requesting a 10-minute session if it's needed in order for them to ask for more time. I'm not really quite sure what that means. Based on the foregoing reasons, counsel requests enlargement of time to file pretrial motions. If argument is required if argument is required, if we need to talk about it, if we have to negotiate about it, then we need to do it in 10 minutes or less. I mean, that's kind of what that means to me. Okay, just skimming over like the first paragraph of this one, it has my eyes doing this because this is interesting. Hopefully I'm wrong, but I don't think I am. Let's go ahead. Motion to make available the record of all proceedings of the grand jury pursuant to ICR 6.2. So before we go further, let's actually go look at that because I still have the ICR rules in my bookmarks. So let's go look up what 6.2 means. Okay, so the Idaho Criminal Rule 6.2 is just the transcript of grand jury proceedings. So it'll be interesting if they get this transcript and Judge called Kaylee Kayla during the grand jury too. Like, I'm telling you, I'm probably going to harp on that for a while because that really just literally pissed me the hell off. Okay, so this states, comes now Bryan C. Kohberger, by and through his attorney, Ann Taylor, public defender, hereby moves the court for an order directing the clerk of court to unseal the record and make it available to allow for examination and to allow for the preparation of transcription of all of the proceedings conducted by the grand jury in the above titled matter, except for the deliberation portion of the proceedings. And then there's a humongous list of things on here. I'm going to just go ahead and put the screenshots. Pause to read. And it ends by stating, this motion is based on the 5th, 6th, and 14th Amendments to the United States Constitution, to the Idaho Constitution, and enabling legislation enacting these guarantees. Furthermore, this motion is made on the grounds that the record of said proceeding is necessary for counsel of the defendant to prepare a defense in this matter, which again is very true. If he doesn't know what was said and presented at the grand jury, then how can they adequately prepare for anything? Counsel for the defendant further moves the court to order that the costs necessary for the preparation and completion of the record be paid at the county expense and at no expense to the defense. This request is made on the grounds that the defendant was determined to be indigent and his representation is provided by the Office of the Public Defender of Kootenai County. Indigent is sort of like those paupers applications they used to call them at hospitals. It's basically just stating he's broke, he's not paying for any of this, so the state has no choice to. So the part that got my attention was the paragraph at the very top that states, directing the clerk of court to unseal the record and make it available to allow for examination. So is that just they want it unsealed for the defense, or are they asking it to be unsealed and made public here? If anyone knows, let me know. And then the fourth one, the last document from today that I've seen so far, is just the court having before it the motion to enlarge time to file pretrial motions and good cause appearing. Now, therefore, it is ordered that defense counsel has 30 days from the receipt of the grand jury materials to file any pretrial motions in the above titled matter. So as soon as they receive the grand jury information, they have 30 days. 30 days to file any pretrial motions necessary. So it'll be interesting to see just how fast they get this information. But that looks to be it for now. When it comes to the documents, if anything else pops up, I'll let you guys know. See y'all.